Comprehensive Nuclear Test Ban Treaty done at New York on 10 September 1996, not yet in force. Preamble. The states parties to this treaty, hereinafter referred to as the states parties, welcoming the international agreements and other positive measures of recent years in the field of nuclear disarmament, including reductions in arsenals of nuclear weapons, as well as in the field of the prevention of nuclear proliferation in all its aspects. Underlining the importance of the full and prompt implementation of such agreements and measures. Convinced that the present international situation provides an opportunity to take further effective measures towards nuclear disarmament and against the proliferation of nuclear weapons in all its aspects, and declaring their intention to take such measures. Stressing therefore the need for continued systematic and progressive efforts to reduce nuclear weapons globally, with the ultimate goal of eliminating those weapons, and of general and complete disarmament under strict and effective international control. Recognizing that the cessation of all nuclear weapon test explosions and all other nuclear explosions, by constraining the development and qualitative improvement of nuclear weapons and ending the development of advanced new types of nuclear weapons, constitutes an effective measure of nuclear disarmament and non-proliferation in all its aspects. Further recognizing that an end to all such nuclear explosions will thus constitute a meaningful step in the realization of a systematic process to achieve nuclear disarmament. Convinced that the most effective way to achieve an end to nuclear testing is through the conclusion of a universal and internationally and effectively verifiable comprehensive nuclear test ban treaty, which has long been one of the highest priority objectives of the international community in the field of disarmament and non-proliferation. Noting the aspirations expressed by the parties to the 1963 treaty banning nuclear weapon tests in the atmosphere, in outer space and underwater to seek to achieve the discontinuance of all test explosions of nuclear weapons for all time. Noting also the views expressed that this treaty could contribute to the protection of the environment. Affirming the purpose of attracting the adherence of all states to this treaty and its objective to contribute effectively to the prevention of the proliferation of nuclear weapons in all its aspects, to the process of nuclear disarmament and therefore to the enhancement of international peace and security. Have agreed as follows. Article I. Basic Obligations. 1. Each state party undertakes not to carry out any nuclear weapon test explosion or any other nuclear explosion, and to prohibit and prevent any such nuclear explosion at any place under its jurisdiction or control. 2. Each state party undertakes, furthermore, to refrain from causing, encouraging, or in any way participating in the carrying out of any nuclear weapon test explosion or any other nuclear explosion. Article 2. The Organization. A. General Provisions 1. The states parties hereby establish the Comprehensive Nuclear Test Ban Treaty Organization, hereinafter referred to as the Organization, to achieve the object and purpose of this treaty, to ensure the implementation of its provisions, including those for international verification of compliance with it, and to provide a forum for consultation and cooperation among states parties. 2. All states parties shall be members of the organization. A state party shall not be deprived of its membership in the organization. 3. The seat of the organization shall be Vienna, Republic of Austria. 4. There are hereby established as organs of the organization, the Conference of the States Parties, the Executive Council and the Technical Secretariat, which shall include the International Data Center. 5. Each state party shall cooperate with the organization in the exercise of its functions in accordance with this treaty. States parties shall consult, directly among themselves, or through the organization or other appropriate international procedures, including procedures within the framework of the United Nations and in accordance with its charter, on any matter which may be raised relating to the object and purpose, or the implementation of the provisions, of this treaty. 6. The organization shall conduct its verification activities provided for under this treaty in the least intrusive manner possible, consistent with the timely and efficient accomplishment of their objectives. It shall request only the information and data necessary to fulfill its responsibilities under this treaty. It shall take every precaution to protect the confidentiality of information on civil and military activities and facilities coming to its knowledge in the implementation of this treaty and, in particular, shall abide by the confidentiality provisions set forth in this treaty. 7. Each state party shall treat as confidential and afford special handling to information and data that it receives in confidence from the organization in connection with the implementation of this treaty. It shall treat such information and data exclusively in connection with its rights and obligations under this treaty. 8. The organization, as an independent body, shall seek to utilize existing expertise and facilities, as appropriate, and to maximize cost efficiencies, through cooperative arrangements with other international organizations such as the International Atomic Energy Agency. Such arrangements, excluding those of a minor and normal commercial and contractual nature, shall be set out in agreements to be submitted to the Conference of the States Parties for approval. 9. The costs of the activities of the organization shall be met annually by the states parties in accordance with the United Nations scale of assessments adjusted to take into account differences in membership between the United Nations and the organization. 10. Financial contributions of states parties to the Preparatory Commission shall be deducted in an appropriate way from their contributions to the regular budget. 11. A member of the organization which is in arrears in the payment of its assessed contribution to the organization shall have no vote in the organization if the amount of its arrears equals or exceeds the amount of the contribution due from it for the preceding 2 full years. The Conference of the States Parties may, nevertheless, permit such a member to vote if it is satisfied that the failure to pay is due to conditions beyond the control of the member. b. The Conference of the States Parties composition, procedures and decision-making. 12. The Conference of the States Parties, hereinafter referred to as the Conference, shall be composed of all states parties. Each state party shall have one representative in the Conference, who may be accompanied by alternates and advisers. 13. The initial session of the Conference shall be convened by the depository no later than 30 days after the entry into force of this treaty. 14. The Conference shall meet in regular sessions, which shall be held annually, unless it decides otherwise. 15. A special session of the Conference shall be convened, a. when decided by the Conference, b. when requested by the Executive Council, or c. when requested by any state party and supported by a majority of the states parties. The special session shall be convened no later than 30 days after the decision of the Conference, the request of the Executive Council, or the attainment of the necessary support, unless specified otherwise in the decision or request. 16. The Conference may also be convened in the form of an amendment conference, in accordance with Article 7. 17. The Conference may also be convened in the form of a review conference, in accordance with Article 8. 18. Sessions shall take place at the seat of the organization unless the Conference decides otherwise. 19. The Conference shall adopt its rules of procedure. At the beginning of each session, it shall elect its president and such other officers as may be required. They shall hold office until a new president and other officers are elected at the next session. 20. A majority of the states parties shall constitute a quorum. 21. Each state party shall have one vote. 22. The Conference shall take decisions on matters of procedure by a majority of members present and voting. Decisions on matters of substance shall be taken as far as possible by consensus. If consensus is not attainable when an issue comes up for decision, the President of the Conference shall defer any vote for 24 hours, and during this period of deferment shall make every effort to facilitate achievement of consensus, and shall report to the Conference before the end of this period. If consensus is not possible at the end of 24 hours, the Conference shall take a decision by a 2/3 majority of members present and voting unless specified otherwise in this treaty. When the issue arises as to whether the question is one of substance or not, that question shall be treated as a matter of substance unless otherwise decided by the majority required for decisions on matters of substance. 23. When exercising its function under paragraph 26(k), the Conference shall take a decision to add any state to the list of states contained in Annex 1 to this treaty in accordance with the procedure for decisions on matters of substance set out in paragraph 22. Notwithstanding paragraph 22, the Conference shall take decisions on any other change to Annex 1 to this treaty by consensus. Powers and Functions 24. The Conference shall be the principal organ of the organization. It shall consider any questions, matters or issues within the scope of this treaty, including those relating to the powers and functions of the Executive Council and the Technical Secretariat, in accordance with this treaty. It may make recommendations and take decisions on any questions, matters or issues within the scope of this treaty raised by a state party or brought to its attention by the Executive Council. 25. The Conference shall oversee the implementation of, and review compliance with, this treaty and act in order to promote its object and purpose. It shall also oversee the activities of the Executive Council and the Technical Secretariat and may issue guidelines to either of them for the exercise of their functions. 26. The Conference shall a. Consider and adopt the report of the organization on the implementation of this treaty in the annual program and budget of the organization, submitted by the Executive Council, as well as consider other reports. b. Decide on the scale of financial contributions to be paid by states parties in accordance with paragraph 9. c. Elect the members of the Executive Council. d. Appoint the Director General of the Technical Secretariat, hereinafter referred to as the Director General. e. Consider and approve the rules of procedure of the Executive Council submitted by the latter. f. Consider and review scientific and technological developments that could affect the operation of this treaty. In this context, the Conference may direct the Director General to establish a scientific advisory board to enable him or her, in the performance of his or her functions, to render specialized advice in areas of science and technology relevant to this treaty to the Conference, to the Executive Council, or to states parties. In that case, the Scientific Advisory Board shall be composed of independent experts serving in their individual capacity and appointed, in accordance with terms of reference adopted by the Conference, on the basis of their expertise and experience in the particular scientific fields relevant to the implementation of this treaty. g. Take the necessary measures to ensure compliance with this treaty and to redress and remedy any situation that contravenes the provisions of this treaty, in accordance with Article v. h. Consider and approve at its initial session any draft agreements, arrangements, provisions, procedures, operational manuals, guidelines and any other documents developed and recommended by the Preparatory Commission. I. Consider and approve agreements or arrangements negotiated by the Technical Secretariat with states parties, other states and international organizations to be concluded by the Executive Council on behalf of the organization in accordance with paragraph 38, h. j. Establish such subsidiary organs as it finds necessary for the exercise of its functions in accordance with this treaty and k. Update Annex 1 to this treaty, as appropriate, in accordance with paragraph 23. c. The Executive Council composition, Procedures and Decision-Making 27. The Executive Council shall consist of 51 members. Each state party shall have the right, in accordance with the provisions of this article, to serve on the Executive Council. 28. Taking into account the need for equitable geographical distribution, the Executive Council shall comprise a. 10 states parties from Africa, b. 7 states parties from Eastern Europe, c. 9 states parties from Latin America and the Caribbean, d. 7 states parties from the Middle East and South Asia, e. 10 states parties from North America and Western Europe and f. 8 states parties from Southeast Asia, the Pacific and the Far East. All states in each of the above geographical regions are listed in Annex 1 to this treaty. Annex 1 to this treaty shall be updated, as appropriate, by the Conference in accordance with paragraphs 23 and 26, k. It shall not be subject to amendments or changes under the procedures contained in Article 7. 29. The members of the Executive Council shall be elected by the Conference. In this connection, each geographical region shall designate states parties from that region for election as members of the Executive Council as follows. A. At least 1/3 of the seats allocated to each geographical region shall be filled, taking into account political and security interests, by states parties in that region designated on the basis of the nuclear capabilities relevant to the treaty as determined by International Date 2, as well as all or any of the following indicative criteria in the order of priority determined by each region. I. Number of monitoring facilities of the International Monitoring System, 2. Expertise and experience in monitoring technology and 3. Contribution to the annual budget of the organization. b. One of the seats allocated to each geographical region shall be filled on a rotational basis by the state party that is first in the English alphabetical order among the states parties in that region that have not served as members of the Executive Council for the longest period of time since becoming states parties or since their last term, whichever is shorter. A state party designated on this basis may decide to forego its seat. In that case, such a state party shall submit a letter of renunciation to the Director General, and the seat that shall be filled by the state party following next in order according to this subparagraph and c. The remaining seats allocated to each geographical region shall be filled by states parties designated from among all the states parties in that region by rotation or elections. 30. Each member of the Executive Council shall have one representative on the Executive Council, who may be accompanied by alternates and advisers. 31. Each member of the Executive Council shall hold office from the end of the session of the conference at which that member is elected until the end of the second regular annual session of the conference thereafter, except that for the first election of the Executive Council, 26 members shall be elected to hold office until the end of the third regular annual session of the conference, due regard being paid to the established numerical proportions as described in paragraph 28. 32. The Executive Council shall elaborate its rules of procedure and submit them to the conference for approval. 33. The Executive Council shall elect its chairman from among its members. 34. The Executive Council shall meet for regular sessions. Between regular sessions it shall meet as may be required for the fulfillment of its powers and functions. 35. Each member of the Executive Council shall have one vote. 36. The Executive Council shall take decisions on matters of procedure by a majority of all its members. The Executive Council shall take decisions on matters of substance by a 2/3 majority of all its members unless specified otherwise in this treaty. When the issue arises as to whether the question is one of substance or not, that question shall be treated as a matter of substance unless otherwise decided by the majority required for decisions on matters of substance. Powers and Functions 37. The Executive Council shall be the executive organ of the organization. It shall be responsible to the conference. It shall carry out the powers and functions entrusted to it in accordance with this treaty. In so doing, it shall act in conformity with the recommendations, decisions and guidelines of the conference and ensure their continuous and proper implementation. 38. The Executive Council shall a. Promote effective implementation of, and compliance with, this treaty. b. Supervise the activities of the Technical Secretariat. c. Make recommendations as necessary to the conference for consideration of further proposals for promoting the object and purpose of this treaty. d. Cooperate with the national authority of each state party. e. Consider and submit to the conference the draft annual program and budget of the organization, the draft report of the organization on the implementation of this treaty, the report on the performance of its own activities and such other reports as it deems necessary or that the conference may request. f. Make arrangements for the sessions of the conference, including the preparation of the draft agenda. g. Examine proposals for changes, on matters of an administrative or technical nature, to the protocol or the annexes thereto, pursuant to Article 7. And make recommendations to the states parties regarding their adoption. h. Conclude, subject to prior approval of the conference, agreements or arrangements with states parties, other states and international organizations on behalf of the organization and supervise their implementation, with the exception of agreements or arrangements referred to in subparagraph I. Approve and supervise the operation of agreements or arrangements relating to the implementation of verification activities with states parties and other states and j. Approve any new operational manuals and any changes to the existing operational manuals that may be proposed by the Technical Secretariat. 39. The Executive Council may request a special session of the conference. 40. The Executive Council shall a. Facilitate cooperation among states parties, and between states parties and the Technical Secretariat, relating to the implementation of this treaty through information exchanges. b. Facilitate consultation and clarification among states parties in accordance with Article 4 and c. Receive, consider and take action on requests for, and reports on-site inspections in accordance with Article 4. 41. The Executive Council shall consider any concern raised by a state party about possible non-compliance with this treaty and abuse of the rights established by this treaty. In so doing, the Executive Council shall consult with the states parties involved and, as appropriate, request a state party to take measures to redress the situation within a specified time. To the extent that the Executive Council considers further action to be necessary, it shall take, inter alia, one or more of the following measures. a. Notify all states parties of the issue or matter. b. Bring the issue or matter to the attention of the conference. c. Make recommendations to the conference or take action, as appropriate, regarding measures to redress the situation and to ensure compliance in accordance with Article v. d. The Technical Secretariat 42. The Technical Secretariat shall assist states parties in the implementation of this treaty. The Technical Secretariat shall assist the Conference and the Executive Council in the performance of their functions. The Technical Secretariat shall carry out the verification and other functions entrusted to it by this treaty, as well as those functions delegated to it by the Conference or the Executive Council in accordance with this treaty. The Technical Secretariat shall include, as an integral part, the International Data Center. 43. The functions of the Technical Secretariat with regard to verification of compliance with this treaty shall, in accordance with Article 4 and the Protocol, include inter alia. a. Being responsible for supervising and coordinating the operation of the International Monitoring System. b. Operating the International Data Center. C. Routinely receiving, processing, analyzing and reporting on international monitoring system data. D. Providing technical assistance in, and support for, the installation and operation of monitoring stations. E. Assisting the Executive Council in facilitating consultation and clarification among states parties. F. Receiving requests for on-site inspections and processing them, facilitating Executive Council consideration of such requests, carrying out the preparations for, and providing technical support during, the conduct of on-site inspections, and reporting to the Executive Council. G. Negotiating agreements or arrangements with states parties, other states and international organizations and concluding, subject to prior approval by the Executive Council, any such agreements or arrangements relating to verification activities with states parties or other states and H. Assisting the states parties through their national authorities on other issues of verification under this treaty. 44. The Technical Secretariat shall develop and maintain, subject to approval by the Executive Council, operational manuals to guide the operation of the various components of the verification regime, in accordance with Article 4 and the Protocol. These manuals shall not constitute integral parts of this treaty or the Protocol and may be changed by the Technical Secretariat subject to approval by the Executive Council. The Technical Secretariat shall promptly inform the states parties of any changes in the operational manuals. 45. The functions of the Technical Secretariat with respect to administrative matters shall include a. Preparing and submitting to the Executive Council the draft program and budget of the organization. b. Preparing and submitting to the Executive Council the draft report of the organization on the implementation of this treaty and such other reports as the Conference or the Executive Council may request. c. Providing administrative and technical support to the Conference, the Executive Council and other subsidiary organs. d. Addressing and receiving communications on behalf of the organization relating to the implementation of this treaty and e. Carrying out the administrative responsibilities related to any agreements between the organization and other international organizations. 46. All requests and notifications by states parties to the organization shall be transmitted through their national authorities to the Director General. Requests and notifications shall be in one of the official languages of this treaty. In response, the Director General shall use the language of the transmitted request or notification. 47. With respect to the responsibilities of the Technical Secretariat for preparing and submitting to the Executive Council the draft program and budget of the organization, the Technical Secretariat shall determine and maintain a clear accounting of all costs for each facility established as part of the international monitoring system. Similar treatment in the draft program and budget shall be accorded to all other activities of the organization. 48. The Technical Secretariat shall promptly inform the Executive Council of any problems that have arisen with regard to the discharge of its functions that have come to its notice in the performance of its activities and that it has been unable to resolve through consultations with the state party concerned. 49. The Technical Secretariat shall comprise a Director General, who shall be its head and chief administrative officer, and such scientific, technical and other personnel as may be required. The Director General shall be appointed by the Conference upon the recommendation of the Executive Council for a term of 4 years, renewable for 1 further term, but not thereafter. The first Director General shall be appointed by the Conference at its initial session upon the recommendation of the Preparatory Commission. 50. The Director General shall be responsible to the Conference and the Executive Council for the appointment of the staff and for the organization and functioning of the Technical Secretariat. The paramount consideration in the employment of the staff and in the determination of the conditions of service shall be the necessity of securing the highest standards of professional expertise, experience, efficiency, competence and integrity. Only citizens of states parties shall serve as the Director General, as inspectors or as members of the professional and clerical staff. Due regard shall be paid to the importance of recruiting the staff on as wide a geographical basis as possible. Recruitment shall be guided by the principle that the staff shall be kept to the minimum necessary for the proper discharge of the responsibilities of the Technical Secretariat. 51. The Director General may, as appropriate, after consultation with the Executive Council, establish temporary working groups of scientific experts to provide recommendations on specific issues. 52. In the performance of their duties, the Director General, the inspectors, the inspection assistants and the members of the staff shall not seek or receive instructions from any government or from any other source external to the organization. They shall refrain from any action that might reflect adversely on their positions as international officers responsible only to the organization. The Director General shall assume responsibility for the activities of an inspection team. 53. Each state party shall respect the exclusively international character of the responsibilities of the Director General, the inspectors, the inspection assistants and the members of the staff and shall not seek to influence them in the discharge of their responsibilities. E. Privileges and immunities. 54. The organization shall enjoy on the territory and in any other place under the jurisdiction or control of a state party such legal capacity and such privileges and immunities as are necessary for the exercise of its functions. 55. Delegates of states parties, together with their alternates and advisers, representatives of members elected to the Executive Council, together with their alternates and advisers, the Director General, the inspectors, the inspection assistants and the members of the staff of the organization shall enjoy such privileges and immunities as are necessary in the independent exercise of their functions in connection with the organization. 56. The legal capacity, privileges and immunities referred to in this article shall be defined in agreements between the organization and the states parties as well as in an agreement between the organization and the state in which the organization is seated. Such agreements shall be considered and approved in accordance with paragraph 26, H, and I. 57. Notwithstanding paragraphs 54 and 55, the privileges and immunities enjoyed by the Director General, the inspectors, the inspection assistants and the members of the staff of the Technical Secretariat during the conduct of verification activities shall be those set forth in the Protocol. Article 3. National Implementation Measures. 1. Each state party shall, in accordance with its constitutional processes, take any necessary measures to implement its obligations under this treaty. In particular, it shall take any necessary measures. A. To prohibit natural and legal persons anywhere on its territory or in any other place under its jurisdiction as recognized by international law from undertaking any activity prohibited to a state party under this treaty. B. To prohibit natural and legal persons from undertaking any such activity anywhere under its control and c. To prohibit, in conformity with international law, natural persons possessing its nationality from undertaking any such activity anywhere. 2. Each state party shall cooperate with other states parties and afford the appropriate form of legal assistance to facilitate the implementation of the obligations under paragraph 1. 3. Each state party shall inform the organization of the measures taken pursuant to this article. 4. In order to fulfill its obligations under the treaty, each state party shall designate or set up a national authority and shall so inform the organization upon entry into force of the treaty for it. The national authority shall serve as the national focal point for liaison with the organization and with other states parties. Article 4. Verification. A. General Provisions 1. In order to verify compliance with this treaty, a verification regime shall be established consisting of the following elements: A. An international monitoring system, B. Consultation and clarification, C. On-site inspections, and D. Confidence-building measures. At entry into force of this treaty, the verification regime shall be capable of meeting the verification requirements of this treaty. 2. Verification activities shall be based on objective information, shall be limited to the subject matter of this treaty, and shall be carried out on the basis of full respect for the sovereignty of states parties and in the least intrusive manner possible, consistent with the effective and timely accomplishment of their objectives. Each state party shall refrain from any abuse of the right of verification. 3. Each state party undertakes in accordance with this treaty to cooperate, through its national authority established pursuant to Article 3, Paragraph 4, with the organization and with other states parties to facilitate the verification of compliance with this treaty by, inter alia, A. Establishing the necessary facilities to participate in these verification measures and establishing the necessary communication. B. Providing data obtained from national stations that are part of the international monitoring system. C. Participating, as appropriate, in a consultation and clarification process. D. Permitting the conduct of on-site inspections, and E. Participating, as appropriate, in confidence-building measures. 4. All states parties, irrespective of their technical and financial capabilities, shall enjoy the equal right of verification and assume the equal obligation to accept verification. 5. For the purposes of this treaty, no state party shall be precluded from using information obtained by national technical means of verification in a manner consistent with generally recognized principles of international law, including that of respect for the sovereignty of states. 6. Without prejudice to the right of states parties to protect sensitive installations, activities or locations not related to this treaty, states parties shall not interfere with elements of the verification regime of this treaty or with national technical means of verification operating in accordance with Paragraph 5. 7. Each state party shall have the right to take measures to protect sensitive installations and to prevent disclosure of confidential information and data not related to this treaty. 8. Moreover, all that necessary measures shall be taken to protect the confidentiality of any information related to civil and military activities and facilities obtained during verification activities. 9. Subject to Paragraph 8, information obtained by the organization through the verification regime established by this treaty shall be made available to all states parties in accordance with the relevant provisions of this treaty and the protocol. 10. The provisions of this treaty shall not be interpreted as restricting the international exchange of data for scientific purposes. 11. Each state party undertakes to cooperate with the organization and with other states parties in the improvement of the verification regime, and in the examination of the verification potential of additional monitoring technologies such as electromagnetic pulse monitoring or satellite monitoring, with a view to developing, when appropriate, specific measures to enhance the efficient and cost-effective verification of this treaty. Such measures shall, when agreed, be incorporated in existing provisions in this treaty, the protocol or as additional sections of the protocol, in accordance with Article 7, or, if appropriate, be reflected in the operational manuals in accordance with Article 2, Paragraph 44. 12. The states parties undertake to promote cooperation among themselves to facilitate and participate in the fullest possible exchange relating to technologies used in the verification of this treaty in order to enable all states parties to strengthen their national implementation of verification measures and to benefit from the application of such technologies for peaceful purposes. 13. The provisions of this treaty shall be implemented in a manner which avoids hampering the economic and technological development of the states parties for further development of the application of atomic energy for peaceful purposes. Verification responsibilities of the Technical Secretariat. 14. In discharging its responsibilities in the area of verification specified in this treaty and the protocol, in cooperation with the states parties, the Technical Secretariat shall, for the purpose of this treaty, a. Make arrangements to receive and distribute data and reporting products relevant to the verification of this treaty in accordance with its provisions, and to maintain a global communications infrastructure appropriate to this task. b. Routinely through its International Data Center, which shall in principle be the focal point within the Technical Secretariat for data storage and data processing. I. Receive and initiate requests for data from the International Monitoring System. 2. Receive data, as appropriate, resulting from the process of consultation and clarification, from on-site inspections, and from confidence-building measures, and 3. Receive other relevant data from states parties and international organizations in accordance with this treaty and the protocol. c. Supervise, coordinate and ensure the operation of the International Monitoring System and its component elements, and of the International Data Center, in accordance with the relevant operational manuals. d. Routinely process, analyze and report on International Monitoring System data according to agreed procedures so as to permit the effective international verification of this treaty and to contribute to the early resolution of compliance concerns. e. Make available all data, both raw and processed, and any reporting products, to all states parties, each state party taking responsibility for the use of International Monitoring System data in accordance with Article 2, Paragraph 7, and with Paragraphs 8 and 13 of this article. f. Provide to all states parties equal, open, convenient and timely access to all stored data. g. Store all data, both raw and processed, and reporting products. h. Coordinate and facilitate requests for additional data from the International Monitoring System. I. Coordinate requests for additional data from one state party to another state party. j. Provide technical assistance in, and support for, the installation and operation of monitoring facilities and respective communication means, where such assistance and support are required by the state concerned. k. Make available to any state party, upon its request, techniques utilized by the Technical Secretariat and its International Data Center in compiling, storing, processing, analyzing and reporting on data from the verification regime, and l. Monitor, assess and report on the overall performance of the International Monitoring System and of the International Data Center. 15. The agreed procedures to be used by the Technical Secretariat in discharging the verification responsibilities referred to in paragraph 14 and detailed in the protocol shall be elaborated in the relevant operational manuals. b. The International Monitoring System. 16. The International Monitoring System shall comprise facilities for seismological monitoring, radionuclide monitoring including certified laboratories, hydroacoustic monitoring, infrasound monitoring, and respective means of communication, and shall be supported by the International Data Center of the Technical Secretariat. 17. The International Monitoring System shall be placed under the authority of the Technical Secretariat. All monitoring facilities of the International Monitoring System shall be owned and operated by the states hosting or otherwise taking responsibility for them in accordance with the protocol. 18. Each state party shall have the right to participate in the international exchange of data and to have access to all data made available to the International Data Center. Each state party shall cooperate with the International Data Center through its national authority. Funding the International Monitoring System. 19. for facilities incorporated into the International Monitoring System and specified in Tables 1A, 2A, 3 and 4 of Annex 1 to the Protocol, and for their functioning, to the extent that such facilities are agreed by the relevant state and the organization to provide data to the International Data Center in accordance with the technical requirements of the Protocol and relevant operational manuals, the organization, as specified in agreements or arrangements pursuant to Part 1, Paragraph 4 of the Protocol, shall meet the costs of a. establishing any new facilities and upgrading existing facilities, unless the state responsible for such facilities meets these costs itself. b. Operating and maintaining international monitoring system facilities, including facility physical security if appropriate, and application of agreed data authentication procedures. c. Transmitting international monitoring system data, raw or processed, to the International Data Center by the most direct and cost-effective means available, including, if necessary, via appropriate communications nodes, from monitoring stations, laboratories, analytical facilities or from national data centers or such data, including samples where appropriate, to laboratory and analytical facilities from monitoring stations and d. Analyzing samples on behalf of the organization. 20. For auxiliary network seismic stations specified in Table 1B of Annex 1 to the Protocol, the organization, as specified in agreements or arrangements pursuant to Part 1, Paragraph 4 of the Protocol, shall meet the costs only of a. Transmitting data to the International Data Center. b. Authenticating data from such stations. c. Upgrading stations to the required technical standard, unless the state responsible for such facilities meets these costs itself. d. If necessary, establishing new stations for the purposes of this treaty where no appropriate facilities currently exist, unless the state responsible for such facilities meets these costs itself, and e. Any other costs related to the provision of data required by the organization as specified in the relevant operational manuals. 21. The organization shall also meet the cost of provision to each state party of its requested selection from the standard range of International Data Center reporting products and services, as specified in Part 1, Section F of the Protocol. The cost of preparation and transmission of any additional data or products shall be met by the requesting state party. 22. The agreements or, if appropriate, arrangements concluded with states parties or states hosting or otherwise taking responsibility for facilities of the International Monitoring System shall contain provisions for meeting these costs. Such provisions may include modalities whereby a state party meets any of the costs referred to in paragraphs 19a and 20c and d, for facilities which it hosts or for which it is responsible, and is compensated by an appropriate reduction in its assessed financial contribution to the organization. Such a reduction shall not exceed 50% of the annual assessed financial contribution of a state party, but may be spread over successive years. A state party may share such a reduction with another state party by agreement or arrangement between themselves and with the concurrence of the Executive Council. The agreements or arrangements referred to in this paragraph shall be approved in accordance with Article 2, paragraphs 26h and 38I. Changes to the International Monitoring System. 23. Any measures referred to in paragraph 11 affecting the International Monitoring System by means of addition or deletion of a monitoring technology shall, when agreed, be incorporated into this treaty and the protocol pursuant to Article 7, paragraphs 1 to 6. 24. The following changes to the International Monitoring System, subject to the agreement of those states directly affected, shall be regarded as matters of an administrative or technical nature pursuant to Article 7, paragraphs 7 and 8. A. changes to the number of facilities specified in the protocol for a given monitoring technology, and b. changes to other details for particular facilities as reflected in the tables of Annex 1 to the protocol, including, inter alia, state responsible for the facility location, name of facility, type of facility, and attribution of a facility between the primary and auxiliary seismic networks. If the Executive Council recommends, pursuant to Article 7, Paragraph 8, d, that such changes be adopted, it shall as a rule also recommend pursuant to Article 7, Paragraph 8, g, that such changes enter into force upon notification by the Director General of their approval. 25. The Director General, in submitting to the Executive Council and States Parties information and evaluation in accordance with Article 7, Paragraph 8, b, shall include in the case of any proposal made pursuant to Paragraph 24. A technical evaluation of the proposal. B. A statement on the administrative and financial impact of the proposal, and c. A report on consultations with states directly affected by the proposal, including indication of their agreement. Temporary arrangements. 26. In cases of significant or irretrievable breakdown of a monitoring facility specified in the tables of Annex 1 to the protocol, or in order to cover other temporary reductions of monitoring coverage, the Director General shall, in consultation and agreement with those states directly affected, and with the approval of the Executive Council, initiate temporary arrangements of no more than 1 year's duration, renewable if necessary by agreement of the Executive Council and of the states directly affected for another year. Such arrangements shall not cause the number of operational facilities of the International Monitoring System to exceed the number specified for the relevant network, shall meet as far as possible the technical and operational requirements specified in the operational manual for the relevant network, and shall be conducted within the budget of the organization. The Director General shall furthermore take steps to rectify the situation and make proposals for its permanent resolution. The Director General shall notify all states parties of any decision taken pursuant to this paragraph. Cooperating national facilities. 27. States parties may also separately establish cooperative arrangements with the organization, in order to make available to the International Data Center supplementary data from national monitoring stations that are not formally part of the International Monitoring System. 28. Such cooperative arrangements may be established as follows: a. Upon request by a state party, and at the expense of that state, the Technical Secretariat shall take the steps required to certify that a given monitoring facility meets the technical and operational requirements specified in the relevant operational manuals for an international monitoring system facility, and make arrangements for the authentication of its data. Subject to the agreement of the Executive Council, the Technical Secretariat shall then formally designate such a facility as a cooperating national facility. The Technical Secretariat shall take the steps required to revalidate its certification as appropriate. b. The Technical Secretariat shall maintain a current list of cooperating national facilities and shall distribute it to all states parties, and c. The International Data Center shall call upon data from cooperating national facilities, if so requested by a state party, for the purposes of facilitating consultation and clarification and the consideration of on-site inspection requests, data transmission costs being borne by that state party. The conditions under which supplementary data from such facilities are made available, and under which the International Data Center may request further or expedited reporting, or clarifications, shall be elaborated in the operational manual for the respective monitoring network. c. Consultation and clarification. 29. Without prejudice to the right of any state party to request an on-site inspection, states parties should, whenever possible, first make every effort to clarify and resolve, among themselves or with or through the organization, any matter which may cause concern about possible non-compliance with the basic obligations of this treaty. 30. A state party that receives a request pursuant to paragraph 29 directly from another state party shall provide the clarification to the requesting state party as soon as possible, but in any case no later than 48 hours after the request. The requesting and requested states parties may keep the Executive Council and the Director General informed of the request and the response. 31. A state party shall have the right to request the Director General to assist in clarifying any matter which may cause concern about possible non-compliance with the basic obligations of this treaty. The Director General shall provide appropriate information in the possession of the Technical Secretariat relevant to such a concern. The Director General shall inform the Executive Council of the request and of the information provided in response, if so requested by the requesting state party. 32. A state party shall have the right to request the Executive Council to obtain clarification from another state party on any matter which may cause concern about possible non-compliance with the basic obligations of this treaty. In such a case, the following shall apply. A. The Executive Council shall forward the request for clarification to the requested state party through the Director General no later than 24 hours after its receipt. B. The requested state party shall provide the clarification to the Executive Council as soon as possible, but in any case no later than 48 hours after receipt of the request. C. The Executive Council shall take note of the clarification and forward it to the requesting state party no later than 24 hours after its receipt. D. If the requesting state party deems the clarification to be inadequate, it shall have the right to request the Executive Council to obtain further clarification from the requested state party. The Executive Council shall inform without delay all other states parties about any request for clarification pursuant to this paragraph as well as any response provided by the requested state party. 33. If the requesting state party considers the clarification obtained under paragraph 32(d) to be unsatisfactory, it shall have the right to request a meeting of the Executive Council in which states parties involved that are not members of the Executive Council shall be entitled to take part. At such a meeting, the Executive Council shall consider the matter and may recommend any measure in accordance with Article V. D. On-site inspections. Request for an on-site inspection. 34. Each state party has the right to request an on-site inspection in accordance with the provisions of this article and Part 2 of the Protocol in the territory or in any other place under the jurisdiction or control of any state party, or in any area beyond the jurisdiction or control of any state. 35. The sole purpose of an on-site inspection shall be to clarify whether a nuclear weapon test explosion or any other nuclear explosion has been carried out in violation of Article I and, to the extent possible, to gather any facts which might assist in identifying any possible violator. 36. The requesting state party shall be under the obligation to keep the on-site inspection request within the scope of this treaty and to provide in the request information in accordance with paragraph 37. The requesting state party shall refrain from unfounded or abusive inspection requests. 37. The on-site inspection request shall be based on information collected by the International Monitoring System, on any relevant technical information obtained by national technical means of verification in a manner consistent with generally recognized principles of international law, or on a combination thereof. The request shall contain information pursuant to Part 2, paragraph 41 of the Protocol. 38. The requesting state party shall present the on-site inspection request to the Executive Council and at the same time to the Director General for the latter to begin immediate processing. Follow-up after submission of an on-site inspection request. 39. The Executive Council shall begin its consideration immediately upon receipt of the on-site inspection request. 40. The Director General, after receiving the on-site inspection request, shall acknowledge receipt of the request to the requesting state party within 2 hours and communicate the request to the state party sought to be inspected within 6 hours. The Director General shall ascertain that the request meets the requirements specified in Part 2, Paragraph 41 of the Protocol, and, if necessary, shall assist the requesting state party in filing the request accordingly, and shall communicate the request to the Executive Council and to all other states parties within 24 hours. 41. When the on-site inspection request fulfills the requirements, the Technical Secretariat shall begin preparations for the on-site inspection without delay. 42. The Director General, upon receipt of an on-site inspection request referring to an inspection area under the jurisdiction or control of a state party, shall immediately seek clarification from the state party sought to be inspected in order to clarify and resolve the concern raised in the request. 43. A state party that receives a request for clarification pursuant to paragraph 42 shall provide the Director General with explanations and with other relevant information available as soon as possible, but no later than 72 hours after receipt of the request for clarification. 44. The Director General, before the Executive Council takes a decision on the on-site inspection request, shall transmit immediately to the Executive Council any additional information available from the International Monitoring System or provided by any state party on the event specified in the request, including any clarification provided pursuant to paragraphs 42 and 43, as well as any other information from within the Technical Secretariat that the Director General deems relevant or that is requested by the Executive Council. 45. Unless the requesting state party considers the concern raised in the on-site inspection request to be resolved and withdraws the request, the Executive Council shall take a decision on the request in accordance with paragraph 46. Executive Council Decisions 46. The Executive Council shall take a decision on the on-site inspection request no later than 96 hours after receipt of the request from the requesting state party. The decision to approve the on-site inspection shall be made by at least 30 affirmative votes of members of the Executive Council. If the Executive Council does not approve the inspection, preparations shall be stopped and no further action on the request shall be taken. 47. No later than 25 days after the approval of the on-site inspection in accordance with paragraph 46, the inspection team shall transmit to the Executive Council, through the Director General, a progress inspection report. The continuation of the inspection shall be considered approved unless the Executive Council, no later than 72 hours after receipt of the progress inspection report, decides by a majority of all its members not to continue the inspection. If the Executive Council decides not to continue the inspection shall be terminated, and the inspection team shall leave the inspection area and the territory of the inspected state party as soon as possible in accordance with Part 2. Paragraphs 109 and 110 of the Protocol. 48. In the course of the on-site inspection, the inspection team may submit to the Executive Council, through the Director General, a proposal to conduct drilling. The Executive Council shall take a decision on such a proposal no later than 72 hours after receipt of the proposal. The decision to approve drilling shall be made by a majority of all members of the Executive Council. 49. The inspection team may request the Executive Council, through the Director General, to extend the inspection duration by a maximum of 70 days beyond the 60-day time frame specified in Part 2, Paragraph 4 of the Protocol, if the inspection team considers such an extension essential to enable it to fulfill its mandate. The inspection team shall indicate in its request which of the activities and techniques listed in Part 2, Paragraph 69 of the Protocol it intends to carry out during the extension period. The Executive Council shall take a decision on the extension request no later than 72 hours after receipt of the request. The decision to approve an extension of the inspection duration shall be made by a majority of all members of the Executive Council. 50. Any time following the approval of the continuation of the on-site inspection in accordance with paragraph 47, the inspection team may submit to the Executive Council, through the Director General, a recommendation to terminate the inspection. Such a recommendation shall be considered approved unless the Executive Council, no later than 72 hours after receipt of the recommendation, decides by a 2/3 majority of all its members not to approve the termination of the inspection. In case of termination of the inspection team shall leave the inspection area and the territory of the inspected state party as soon as possible in accordance with Part 2, paragraphs 109 and 110 of the Protocol. 51. The requesting state party and the state party sought to be inspected may participate in the deliberations of the Executive Council on the on-site inspection request without voting. The requesting state party and the inspected state party may also participate without voting in any subsequent deliberations of the Executive Council related to the inspection. 52. The Director General shall notify all states parties within 24 hours about any decision by and reports, proposals, requests and recommendations to the Executive Council pursuant to paragraphs 46 to 50. Follow-up after Executive Council approval of an on-site inspection. 53. An on-site inspection approved by the Executive Council shall be conducted without delay by an inspection team designated by the Director General and in accordance with the provisions of this treaty and the Protocol. The inspection team shall arrive at the point of entry no later than 6 days following the receipt by the Executive Council of the on-site inspection request from the requesting state party. 54. The Director General shall issue an inspection mandate for the conduct of the on-site inspection. The inspection mandate shall contain the information specified in Part 2, paragraph 42 of the Protocol. 55. The Director General shall notify the inspected state party of the inspection no less than 24 hours before the planned arrival of the inspection team at the point of entry, in accordance with Part 2, paragraph 43 of the Protocol. The conduct of an on-site inspection. 56. Each state party shall permit the organization to conduct an on-site inspection on its territory or at places under its jurisdiction or control in accordance with the provisions of this treaty and the Protocol. However, no state party shall have to accept simultaneous on-site inspections on its territory or at places under its jurisdiction or control. 57. In accordance with the provisions of this treaty and the Protocol, the inspected state party shall have a. The right and the obligation to make every reasonable effort to demonstrate its compliance with this treaty and, to this end, to enable the inspection team to fulfill its mandate. b. The right to take measures it deems necessary to protect national security interests and to prevent disclosure of confidential information not related to the purpose of the inspection. c. The obligation to provide access within the inspection area for the sole purpose of determining facts relevant to the purpose of the inspection, taking into account subparagraph b, and any constitutional obligations it may have with regard to proprietary rights or searches and seizures. d. The obligation not to invoke this paragraph or Part 2. Paragraph 88 of the Protocol to conceal any violation of its obligations under Article I and E, the obligation not to impede the ability of the inspection team to move within the inspection area and to carry out inspection activities in accordance with this treaty and the Protocol. Access, in the context of an on-site inspection, means both the physical access of the inspection team and the inspection equipment to, and the conduct of inspection activities within, the inspection area. 58. The on-site inspection shall be conducted in the least intrusive manner possible, consistent with the efficient and timely accomplishment of the inspection mandate, and in accordance with the procedures set forth in the protocol. Wherever possible, the inspection team shall begin with the least intrusive procedures and then proceed to more intrusive procedures only as it deems necessary to collect sufficient information to clarify the concern about possible non-compliance with this treaty. The inspectors shall seek only the information and data necessary for the purpose of the inspection and shall seek to minimize interference with normal operations of the inspected state party. 59. The inspected state party shall assist the inspection team throughout the on-site inspection and facilitate its task. 60. If the inspected state party, acting in accordance with Part 2, paragraphs 86 to 96 of the Protocol, restricts access within the inspection area, it shall make every reasonable effort in consultations with the inspection team to demonstrate through alternative means its compliance with this treaty. Observer. 61. With regard to an observer, the following shall apply. A. The requesting state party, subject to the agreement of the inspected state party, may send a representative, who shall be a national either of the requesting state party or of a third state party, to observe the conduct of the on-site inspection. B. The inspected state party shall notify its acceptance or non-acceptance of the proposed observer to the Director General within 12 hours after approval of the on-site inspection by the Executive Council. C. In case of acceptance, the inspected state party shall grant access to the observer in accordance with the protocol. D. The inspected state party shall, as a rule, accept the proposed observer, but if the inspected state party exercises a refusal, that fact shall be recorded in the inspection report. There shall be no more than 3 observers from an aggregate of requesting states parties. Reports of an on-site inspection. 62. Inspection reports shall contain a. A description of the activities conducted by the inspection team. B. The factual findings of the inspection team relevant to the purpose of the inspection. C. An account of the cooperation granted during the on-site inspection. D. A factual description of the extent of the access granted, including the alternative means provided to the team during the on-site inspection, and E. Any other details relevant to the purpose of the inspection. Differing observations made by inspectors may be attached to the report. 63. The Director General shall make draft inspection reports available to the inspected state party. The inspected state party shall have the right to provide the Director General within 48 hours with its comments and explanations, and to identify any information and data which, in its view, are not related to the purpose of the inspection and should not be circulated outside the Technical Secretariat. The Director General shall consider the proposals for changes to the draft inspection report made by the inspected state party and shall wherever possible incorporate them. The Director General shall also annex the comments and explanations provided by the inspected state party to the inspection report. 64. The Director General shall promptly transmit the inspection report to the requesting state party, the inspected state party, the Executive Council and to all other states parties. The Director General shall further transmit promptly to the Executive Council and to all other states parties any results of sample analysis in designated laboratories in accordance with Part 2, paragraph 104 of the Protocol, relevant data from the International Monitoring System, the assessments of the requesting and inspected states parties, as well as any other information that the Director General deems relevant. In the case of the progress inspection report referred to in paragraph 47, the Director General shall transmit the report to the Executive Council within the time frame specified in that paragraph. 65. The Executive Council, in accordance with its powers and functions, shall review the inspection report and any material provided pursuant to paragraph 64, and shall address any concerns as to a. whether any non-compliance with this treaty has occurred, and b. whether the right to request an on-site inspection has been abused. 66. If the Executive Council reaches the conclusion, in keeping with its powers and functions, that further action may be necessary with regard to paragraph 65, it shall take the appropriate measures in accordance with Article V. Frivolous or abusive on-site inspection requests. 67. If the Executive Council does not approve the on-site inspection on the basis that the on-site inspection request is frivolous or abusive, or if the inspection is terminated for the same reasons, the Executive Council shall consider and decide on whether to implement appropriate measures to redress the situation, including the following. A. Requiring the requesting state party to pay for the cost of any preparations made by the Technical Secretariat. B. Suspending the right of the requesting state party to request an on-site inspection for a period of time, as determined by the Executive Council, and c. Suspending the right of the requesting state party to serve on the Executive Council for a period of time. 68. In order to e. Confidence-building measures. A. Contribute to the timely resolution of any compliance concerns arising from possible misinterpretation of verification data relating to chemical explosions, and b. Assist in the calibration of the stations that are part of the component networks of the International Monitoring System. Each state party undertakes to cooperate with the organization and with other states parties in implementing relevant measures as set out in Part 3 of the Protocol. Article V. Measures to redress a situation and to ensure compliance, including sanctions. 1. The Conference, taking into account, inter alia, the recommendations of the Executive Council, shall take the necessary measures, as set forth in paragraphs 2 and 3, to ensure compliance with this treaty and to redress and remedy any situation which contravenes the provisions of this treaty. 2. In cases where a state party has been requested by the Conference or the Executive Council to redress a situation raising problems with regard to its compliance and fails to fulfill the request within the specified time, the Conference may, inter alia, decide to restrict or suspend the state party from the exercise of its rights and privileges under this treaty until the Conference decides otherwise. 3. In cases where damage to the object and purpose of this treaty may result from non-compliance with the basic obligations of this treaty, the Conference may recommend to states parties collective measures which are in conformity with international law. 4. The Conference, or alternatively, if the case is urgent, the Executive Council, may bring the issue, including relevant information and conclusions, to the attention of the United Nations. Article V. Settlement of disputes. 1. Disputes that may arise concerning the application or the interpretation of this treaty shall be settled in accordance with the relevant provisions of this treaty and in conformity with the provisions of the Charter of the United Nations. 2. When a dispute arises between two or more states parties, or between one or more states parties and the organization, relating to the application or interpretation of this treaty, the parties concerned shall consult together with a view to the expeditious settlement of the dispute by negotiation or by other peaceful means of the parties' choice, including recourse to appropriate organs of this treaty and, by mutual consent, referral to the International Court of Justice in conformity with the statute of the court. The parties involved shall keep the Executive Council informed of actions being taken. 3. The Executive Council may contribute to the settlement of a dispute that may arise concerning the application or interpretation of this treaty by whatever means it deems appropriate, including offering its good offices, calling upon the states parties to a dispute to seek a settlement through a process of their own choice, bringing the matter to the attention of the Conference and recommending a time limit for any agreed procedure. 4. The conference shall consider questions related to disputes raised by states parties or brought to its attention by the Executive Council. The conference shall, as it finds necessary, establish or entrust organs with tasks related to the settlement of these disputes in conformity with Article 2, paragraph 26, J. 5. The Conference and the Executive Council are separately empowered, subject to authorization from the General Assembly of the United Nations, to request the International Court of Justice to give an advisory opinion on any legal question arising within the scope of the activities of the organization. An agreement between the organization and the United Nations shall be concluded for this purpose in accordance with Article 2, paragraph 38, H. 6. This article is without prejudice to Articles 4 and v. Article 7. Amendments. 1. At any time after the entry into force of this treaty, any state party may propose amendments to this treaty, the protocol, or the annexes to the protocol. Any state party may also propose changes, in accordance with paragraph 7, to the protocol or the annexes thereto. Proposals for amendments shall be subject to the procedures in paragraphs 2 to 6. Proposals for changes, in accordance with paragraph 7, shall be subject to the procedures in paragraph 8. 2. The proposed amendment shall be considered and adopted only by an amendment conference. 3. Any proposal for an amendment shall be communicated to the Director General, who shall circulate it to all states parties and the depository and seek the views of the states parties on whether an amendment conference should be convened to consider the proposal. If a majority of the states parties notify the Director General no later than 30 days after its circulation that they support further consideration of the proposal, the Director General shall convene an amendment conference to which all states parties shall be invited. 4. The amendment conference shall be held immediately following a regular session of the conference unless all states parties that support the convening of an amendment conference request that it be held earlier. In no case shall an amendment conference be held less than 60 days after the circulation of the proposed amendment. 5. Amendments shall be adopted by the amendment conference by a positive vote of a majority of the states parties with no state party casting a negative vote. 6. Amendments shall enter into force for all states parties 30 days after deposit of the instruments of ratification or acceptance by all those states parties casting a positive vote at the amendment conference. 7. In order to ensure the viability and effectiveness of this treaty, Parts I and 3 of the Protocol and Annexes 1 and 2 to the Protocol shall be subject to changes in accordance with paragraph 8, if the proposed changes are related only to matters of an administrative or technical nature. All other provisions of the Protocol and the Annexes thereto shall not be subject to changes in accordance with paragraph 8. 8. Proposed changes referred to in paragraph 7 shall be made in accordance with the following procedures. A. The text of the proposed changes shall be transmitted together with the necessary information to the Director General. Additional information for the evaluation of the proposal may be provided by any state party and the Director General. The Director General shall promptly communicate any such proposals and information to all states parties, the Executive Council and the depository. B. No later than 60 days after its receipt, the Director General shall evaluate the proposal to determine all its possible consequences for the provisions of this treaty and its implementation and shall communicate any such information to all states parties and the Executive Council. C. The Executive Council shall examine the proposal in the light of all information available to it, including whether the proposal fulfills the requirements of paragraph 7. No later than 90 days after its receipt, the Executive Council shall notify its recommendation, with appropriate explanations, to all states parties for consideration. States parties shall acknowledge receipt within 10 days. D. If the Executive Council recommends to all states parties that the proposal be adopted, it shall be considered approved if no state party objects to it within 90 days after receipt of the recommendation. If the Executive Council recommends that the proposal be rejected, it shall be considered rejected if no state party objects to the rejection within 90 days after receipt of the recommendation. If a recommendation of the Executive Council does not meet with the acceptance required under subparagraph D, a decision on the proposal, including whether it fulfills the requirements of paragraph 7, shall be taken as a matter of substance by the Conference at its next session. The Director General shall notify all states parties and the depository of any decision under this paragraph. Changes approved under this procedure shall enter into force for all states parties 180 days after the date of notification by the Director General of their approval unless another time period is recommended by the Executive Council or decided by the Conference. Article 8. Review of the Treaty. 1. Unless otherwise decided by a majority of the states parties, 10 years after the entry into force of this treaty, a conference of the states parties shall be held to review the operation and effectiveness of this treaty, with a view to assuring itself that the objectives and purposes in the preamble and the provisions of the treaty are being realized. Such review shall take into account any new scientific and technological developments relevant to this treaty. On the basis of a request by any state party, the review conference shall consider the possibility of permitting the conduct of underground nuclear explosions for peaceful purposes. If the review conference decides by consensus that such nuclear explosions may be permitted, it shall commence work without delay, with a view to recommending to states parties an appropriate amendment to this treaty that shall preclude any military benefits of such nuclear explosions. Any such proposed amendment shall be communicated to the Director General by any state party and shall be dealt with in accordance with the provisions of Article 7. 2. At intervals of 10 years thereafter, further review conferences may be convened with the same objective, if the conference so decides as a matter of procedure in the preceding year. Such conferences may be convened after an interval of less than 10 years if so decided by the conference as a matter of substance. 3. Normally, any review conference shall be held immediately following the regular annual session of the conference provided for in Article 2. Article 9. Duration and withdrawal. 1. This treaty shall be of unlimited duration. 2. Each state party shall, in exercising its national sovereignty, have the right to withdraw from this treaty if it decides that extraordinary events related to the subject matter of this treaty have jeopardized its supreme interests. 3. Withdrawal shall be effected by giving notice 6 months in advance to all other states parties, the Executive Council, the Depository and the United Nations Security Council. Notice of withdrawal shall include a statement of the extraordinary event or events which a state party regards as jeopardizing its supreme interests. Article X. Status of the Protocol and the Annexes. The annexes to this treaty, the Protocol, and the annexes to the Protocol form an integral part of the treaty. Any reference to this treaty includes the annexes to this treaty, the Protocol and the annexes to the Protocol. Article 11. Signature. This treaty shall be open to all states for signature before its entry into force. Article 12. Ratification. This treaty shall be subject to ratification by states signatories according to their respective constitutional processes. Article 13. Accession. Any state which does not sign this treaty before its entry into force may accede to it at any time thereafter. Article 14. Entry into force. 1. This treaty shall enter into force 180 days after the date of deposit of the instruments of ratification by all states listed in Annex 2 to this treaty, but in no case earlier than 2 years after its opening for signature. 2. If this treaty has not entered into force 3 years after the date of the anniversary of its opening for signature, the depository shall convene a conference of the states that have already deposited their instruments of ratification upon the request of majority of those states. That conference shall examine the extent to which the requirement set out in paragraph 1 has been met and shall consider and decide by consensus what measures consistent with international law may be undertaken to accelerate the ratification process in order to facilitate the early entry into force of this treaty. 3. Unless otherwise decided by the conference referred to in paragraph 2 or other such conferences, this process shall be repeated at subsequent anniversaries of the opening for signature of this treaty, until its entry into force. 4. All states signatories shall be invited to attend the conference referred to in paragraph 2 and any subsequent conferences as referred to in paragraph 3, as observers. 5. For states whose instruments of ratification or accession are deposited subsequent to the entry into force of this treaty, it shall enter into force on the 30th day following the date of deposit of their instruments of ratification or accession. Article 15. Reservations. The articles of and the annexes to this treaty shall not be subject to reservations. The provisions of the protocol to this treaty and the annexes to the protocol shall not be subject to reservations incompatible with the object and purpose of this treaty. Article 16. Depository. 1. The Secretary-General of the United Nations shall be the depository of this treaty and shall receive signatures, instruments of ratification and instruments of accession. 2. The depository shall promptly inform all states signatories and acceding states of the date of each signature, the date of deposit of each instrument of ratification or accession, the date of the entry into force of this treaty and of any amendments and changes thereto, and the receipt of other notices. 3. The depository shall send duly certified copies of this treaty to the governments of the states signatories and acceding states. 4. This treaty shall be registered by the depository pursuant to Article 102 of the Charter of the United Nations. Article 17. Authentic texts. This treaty, of which the Arabic, Chinese, English, French, Russian and Spanish texts are equally authentic, shall be deposited with the Secretary-General of the United Nations. Annex 1 to the treaty. List of states pursuant to Article 2, Paragraph 28 Africa, Algeria, Angola, Benin, Botswana, Burkina Faso, Burundi, Cameroon, Cape Verde, Central African Republic, Chad, Comoros, Congo, Côte d'Ivoire, Djibouti, Egypt, Equatorial Guinea, Eritrea, Ethiopia, Gabon, Gambia, Ghana, Guinea, Guinea-Bissau, Kenya, Lesotho, Liberia, Libyan Arab Jamhuriya, Madagascar, Malawi, Mali, Mauritania, Mauritius, Morocco, Mozambique, Namibia, Niger, Nigeria, Rwanda, São Tomé and Príncipe, Senegal, Seychelles, Sierra Leone, Somalia, South Africa, Sudan, Swaziland, Togo, Tunisia, Uganda, United Republic of Tanzania, Zaire, Zambia, Zimbabwe. Eastern Europe, Albania, Armenia, Azerbaijan, Belarus, Bosnia and Herzegovina, Bulgaria, Croatia, Czech Republic, Estonia, Georgia, Hungary, Latvia, Lithuania, Poland, Republic of Moldova, Romania, Russian Federation, Slovakia, Slovenia, the former Yugoslav Republic of Macedonia, Ukraine, Yugoslavia. Latin America and the Caribbean, Antigua and Barbuda, Argentina, Bahamas, Barbados, Belize, Bolivia, Brazil, Chile, Colombia, Costa Rica, Cuba, Dominica, Dominican Republic, Ecuador, El Salvador, Grenada, Guatemala, Guyana, Haiti, Honduras, Jamaica, Mexico, Nicaragua, Panama, Paraguay, Peru, St. Kitts and Nevis, St. Lucia, St. Vincent and the Grenadines, Suriname, Trinidad and Tobago, Uruguay, Venezuela. Middle East and South Asia: Afghanistan, Bahrain, Bangladesh, Bhutan, India, Iran, Islamic Republic of Iraq, Israel, Jordan, Kazakhstan, Kuwait, Kyrgyzstan, Lebanon, Maldives, Nepal, Oman, Pakistan, Qatar, Saudi Arabia, Sri Lanka, Syrian Arab Republic, Tajikistan, Turkmenistan, United Arab Emirates, Uzbekistan, Yemen. North America and Western Europe: Andorra, Austria, Belgium, Canada, Cyprus, Denmark, Finland, France, Germany, Greece, Holy See, Iceland, Ireland, Italy, Liechtenstein, Luxembourg, Malta, Monaco, Netherlands, Norway, Portugal, San Marino, Spain, Sweden, Switzerland, Turkey, United Kingdom of Great Britain and Northern Ireland, United States of America. Southeast Asia, the Pacific and the Far East: Australia, Brunei Darussalam, Cambodia, China, Cook Islands, Democratic People's Republic of Korea, Fiji, Indonesia, Japan, Kiribati, Lao People's Democratic Republic, Malaysia, Marshall Islands, Micronesia, Federated States of Mongolia, Myanmar, Nauru, New Zealand, Niue, Palau, Papua New Guinea, Philippines, Republic of Korea, Samoa, Singapore, Solomon Islands, Thailand, Tonga, Tuvalu, Vanuatu, Vietnam. Annex II to the treaty. List of states pursuant to Article 14. List of states members of the Conference on Disarmament as at the 18th of June 1996 which formally participated in the work of the 1996 session of the conference and which appear in Table 1 of the International Atomic Energy Agency's April 1996 edition of nuclear power reactors in the world, and of states members of the Conference on Disarmament as at the 18th of June 1996 which formally participated in the work of the 1996 session of the conference and which appear in Table 1 of the International Atomic Energy Agency's December 1995 edition of nuclear research reactors in the world: Algeria, Argentina, Australia, Austria, Bangladesh, Belgium, Brazil, Bulgaria, Canada, Chile, China, Colombia, Democratic People's Republic of Korea, Egypt, Finland, France, Germany, Hungary, India, Indonesia, Iran, Islamic Republic of Israel, Italy, Japan, Mexico, Netherlands, Norway, Pakistan, Peru, Poland, Romania, Republic of Korea, Russian Federation, Slovakia, South Africa, Spain, Sweden, Switzerland, Turkey, Ukraine, United Kingdom of Great Britain and Northern Ireland, United States of America, Vietnam, Zaire,